Approval of the minutes from the November 15th, 2021 meeting of the Rules Committee. Is there a motion to approve?
So moved, Judge Bellis.
It's been moved by Judge Bellis. Is there a second?
Second, Judge Cobb.
Thank you. Are there any additions or deletions from the minutes? If not, all in favor say aye.
Aye.
Aye. Aye.
Aye.
Opposed say no. That passes unanimously. Do we have Judge Gold and Attorney Pierre for the next item?
I believe we do, Your Honor.
Okay, so the next item is 2019-004, a proposal from Attorney Natasha Pierre, the State Victim Advocate, to change various rules. This has been before us previously, and it was on our agenda last month, but Attorney Pierre was not available at that time, so we put it over until this month. I see Judge Gold, and there's Attorney Pierre. Welcome. So as I understood it, and Attorney Del Campo, correct me if I'm wrong, but as I understood it, we had asked Judge Gold to meet with Attorney Pierre and see if there was any common ground that could be reported on this proposal to us. Is that correct, Joe?
Yes, sir. Yes, there was going to meet to decide whether or not some procedures or policies outside of the rules, I believe, could accommodate these concerns.
I'll hand it over to Judge Gold at this point, and then as necessary, Attorney Pierre.
Thank you, Justice McDonald. If it's all right with you, last time this was down, I chose not to really speak on behalf of Ms. Pierre. And if it's all right with you, sir, I'll just ask Attorney Pierre maybe to speak on the progress we've made since the last meeting.
That's fine.
All right.
Okay. Hello, everyone. Thank you for bringing this up. Again, I apologize for not being able to attend the last meeting. Yes, Judge Gold and I have met a few times since the suggestion was made that we start talking. We've come up with a few ideas to address notification, some training, and possibly a rule, but we wouldn't really know if we'd have to have a rule book change until we implement some of these ideas. So I thank you for this opportunity because it opened a dialogue, and we're at a point where things are moving, and we also want to get the state's attorney involved in the things we agreed upon, which we think will really impact some of my concerns. So at this point, I don't know what the process would be, but I don't see us continuing in this format on this issue at this time.
Well, then, first of all, let me thank both you and Judge Gold for working through some of these issues. I think it would be the preference of our committee to not undertake any additional work on this until you've had such time as you need to talk with the Chief State's Attorney and have potential further discussions. I like to think that if we can work things out amiably, it's better than unnecessarily procuring a rule. So I would recommend to the committee that we table this indefinitely until such time as somebody asks us to revisit it or some version of that. Is there any objection from members of the committee to proceeding in that manner? Hearing none, again, let me thank both Judge Gold and Attorney Pierre for their work on behalf of the committee. So thank you.
Thank you.
Thank you.
I see that the chief is on, and rather than waste his time, I'm going to take an item out of order, and that is 2021-015, the proposal from the Chief Justice regarding a new rule eliminating peremptory challenges based on race or ethnicity. Attorney Del Campo, why don't you just remind us what material that has been submitted to us is new from last month?
Yes, Your Honor. The new materials from last month are the comments submitted from Chief State's Attorney Colangelo. The comments were submitted from Attorney Daniel Krish. Comments from Judge Trial Referee Douglas Levine, and comments from the Chief Public Defender Christine Rapillo. Those are all new materials that have been submitted.
Thank you. Chief Justice, was there anything you wanted to talk about before we begin talking amongst the members of the committee?
No, give me a second here. My desk is going crazy. It's actually moving by itself. I have no idea what's going on. I apologize for that. Hopefully it won't go anymore. Thank you. I was concerned about some of the comments that are coming in, and I was going to try to address them. But as I've been reading the comments, I see that there's a well-rounded discussion that's going on. So I appreciate that. So I don't need any extra time for that. However, I am highly interested in the deliberations and everything else that goes on with this matter. So I will stay in contact as much as I can. And of course, I support the rule change 100%. I think it's vitally necessary. Thank you.
Attorney Del Campo, do you happen to know which members of the task force are in attendance? I do see Attorney Joette Katz is on, but I can't tell from my vantage point who else from the task force might be on.
Let's see.
Is Judge Levine?
I do not see Judge Levine.
All right, why don't I do it this way? Would any member of the task force who's attending please announce themselves, and we'll hopefully not speak over each other.
Your Honor, this is Daniel Krish. I'm attending.
Thank you.
Your Honor, Neil Feigenson attending. Oh, I'm sorry.
That's okay. Chase Rogers attending.
David Gold. Attending.
Charlene Merced.
I heard Judge Gold, and who was next?
Charlene Merced.
Thank you.
Chris Rapillo.
Attorney Rapillo, and somebody else.
Jury Administrator Esther Harris.
Thank you.
Your Honor, Preston Tisdale is present.
Thank you. Any other members of the task force? Okay. So why don't I open this up to members of the committee to talk about any concerns or observations that they'd like to address to either the committee or to pose any questions in particular to any members of the task force.
I have a question.
Judge Farley.
Yes, thank you. What has come up for some of us is whether the task force contemplated that the rule would apply in civil cases. The language of the rule suggests that it would. On the other hand, the task force considered and rejected the idea of having judges sit in on jury selection in civil cases. And it seems like the rule would be pretty difficult to apply without a record and a judge presiding. And I did notice that in Holmes, the court anticipated that there might be reforms that would only apply in criminal cases. I don't know whether the task force intended that this be one of them, but I would like to know if anyone from the task force can explain what the intent is when it comes to civil jury selection.
And I believe, if I recall correctly, that former Chief Justice Rogers was the co-chair of the task force. So let me ask her who amongst the task force members, if not her, would be the right person to address Judge Farley's concern.
Thank you. So I think that Mr. Krish can probably give more specifics, but my recollection is that it was going to be for civil cases as well. And I think the theory, Judge Farley, would be that to the extent an issue was coming up, then the judge in a civil case would make themselves available, just like they do on a discretionary basis currently to create a record regarding any particular potential jury member.
Thank you. Attorney Krish, would you like to add anything?
No, I agree entirely with Chief Justice Rogers.
Judge Farley?
Okay, yeah. I think that we could make it a little clearer than that the court, well, I guess the question is, would the court be expected to apply the rule by recreating the records? We sometimes do when there's a challenge for cause. Some of the circumstances that the court has to consider under paragraph F, I don't know how you would do that without having had a record not only of the particular juror in question, but all the other jurors that had already been voir dire.
Attorney Krish or former Chief Justice Rogers?
So now I'm sort of spitballing, but because I think it's a good point you're raising. But I wonder if you could have the voir dire recorded so that then the judge could listen to the transcript of it or the FTR of it to the extent necessary to still achieve the same purposes. Any thoughts on that?
Well, I was going to suggest maybe that Justice Katz, Preston Tisdale, who were on the working group, so the smaller subset of our subcommittee that specifically worked on drafting the rule, might have some thoughts about that. We only recommended, for administrative reasons, and I think recognition of how hard judges already work, reasons to not require judges to preside over civil jury selection. But if it's impossible to make this rule work in civil cases without that, that's an administrative choice, I think, for the branch to make in terms of availability and manpower. It's not a legal question. It's simply a question. We didn't say there's a legal reason why you should make that distinction. It was our discussion, at least that I recall, was solely about practicality and availability of judges to preside over civil jury selection. But I defer, especially to Joette and Preston, but I think we're both on that working group.
Let's go first to Joette Katz.
Who has to unmute herself. Yes, thank you. Thank you very much for the opportunity and the question. And I would also include in the dialogue Judge Gold. Judge Levine is in the middle of a mediation today. It's my understanding, and Judge Gold, who chaired this particular subcommittee, is also with us. I think Attorney Krish's point is exactly correct. In other words, the legal requirements, the legal propositions, the interests at stake, I think all pertain equally to the civil arena. The question really is one of mechanics. And I'd rather not have that drive personally. And I think in terms of our own expectations, the tail should not be wagging the dog, so to speak. So if this is, if the Rules Committee at the end of the day determines that this is good policy, and the Chief Justice, and obviously the Chief Justice believes very strongly, as do all of us in this entire enterprise, then I think we make the accommodation for the mechanics. And whether it's, as Chief Justice Rogers said, taping it and then having it there for purposes of argument later on when the objection is actually made and the issue comes up. I think that's a mechanics one, and it's an issue of funding, and it seems in the scope of things, or in the scheme of things, relatively modest or minor accommodation to be made. So that would be my answer to your question. I don't know if Judge Gold has anything further to say, or Preston Tisdale, or actually Chris Rapillo, who is also on the committee with us, and then Neil Feigenson as well, if anybody else wants to, and not to steal your order, Justice McDonald, or your suggestion, but to include them in any further conversation.
Thank you. Let me turn first to Judge Gold because I can actually see him on my screen.
Thank you. Yeah, I think simply put, it was the intention that this would apply equally to criminal and civil cases. So that's all that I'll say. To both sides, defense and prosecution, and defense and plaintiff's bar.
Was there, let me just jump in here, was there any discussion about any of the potential difficulties of recreating a record by the subcommittee?
I don't recall any specific discussion of that, but I tend to agree with the comments that have already been made by those that have spoke before me, that we recognize it would come with some logistical challenges, but it I think was the consensus that this rule, if it is important enough to enact in criminal cases, is equally important in civil, and the civil courts should also do away with challenges that are race or ethnic based.
Thank you. Would any of the others who were identified care to share any insights on this issue? Maybe we'll start with Preston Tisdale.
Sure, thank you. I would agree with what has been said.
We're having a very hard time hearing you, Preston.
Okay, can you hear me now?
Not really.
Okay, I'm gonna, if you can take someone else, and I will address this audio problem.
Thank you. Actually, I see the Chief Justice has raised his virtual hand.
Thank you, Mr. Chair. As you know, the civil jury selection and criminal jury selection has been different historically in the state of Connecticut. And there are some administrative issues that I can take care of on the civil side. The committee has already told you that the intention was to cover civil too. So if you need to make that more clear, that's fine with me. But as far as the administrative rollout of it, I can take care of that, or any other Chief Justice can take care of that as an administrative process with the Chief Court Administrator. So instead of tinkering around with exactly how you're going to do it, I would leave that up to administration and we'll take care of that. But it does apply to civil as well as criminal.
I appreciate that. And you know, yeah, we're not operational management folks here. This is a policy decision. And I would imagine that that is something that the Chief Justice could take up with the Chief Court Administrator. I actually do have to say I like former Chief Justice Rogers' suggestion, if it's feasible, to just do the FTR. That way you're not having attorneys try to paraphrase or recast something when a judge is out on the bench. So I think, is there any other concerns on the civil side based on what was represented? Judge Cobb.
Yeah, I mean, I agree. It would be great if we could have FTR recording all of the jury selections, but I'm in Hartford right now, and in any normal week, we can have trials going on and 5 jury selections at one time. As things presently stand with court monitors, we simply would not have enough monitors to cover all of those events. That's a practical solution, and you know, I'm sure it can be fixed, but if it were to go into effect, say, you know, in a couple weeks, we don't have the monitors to do it. I just want to, that's a very practical situation, but it is one that exists, and it would certainly have to be addressed in the civil context. I do, however, support the task force's intent to apply it to both. It should be, I agree with the intent and the motivation of it.
I'm sorry, Justice McDonald, if I could just follow up for one quick second. I mean, the other point that those of us on the committee have not yet made or reinforced is that this is also a right, obviously, that belongs to prospective jurors. And so to draw, there's the idea of drawing a distinction between jurors who are selected to go into courtroom 6A versus jurors who are selected to go into courtroom 6B, hypothetically, civil versus criminal, and that they're somehow second-class citizens, or they're entitled to fewer constitutional protections of the right to sit is certainly not anything that any one of us would have ever intended.
Let me ask Attorney Del Campo, because this is a timeline issue. Even if we approve this today, it would be the subject of a public hearing in March, I think, and then or May.
May,
and then,
yes.
In May, and then the judges would have to vote on it or any modified version of it at the annual meeting in June, right? June?
Yes, Your Honor.
Okay, I can never keep that straight. With an effective date of when?
The practice book says not earlier than 60 days after promulgation, which is publication in the law journal, but that can be waived. So you could probably have it as early as upon publication, which would be mid-July.
So all of which is to say that I think that amount of lead time would give the Chief Justice and the Chief Court Administrator the time to figure out the logistics and feasibility of doing the FTR type of recording. And if they needed any additional time or resources, they might ask for more money in the budget before the legislature, but we would have those answers well before any final vote by the judges at the annual meeting. And if we had to adjust an effective date based on any developments in the interim, I think we would be able to do that. Does that, at least for right now, Judge Cobb and Judge Farley, is that sufficient for your purposes?
Yes, for
Yeah,
Judge Cobb.
it would be terrific if we could actually get the record, in a civil case, not only for this issue, but for others, I suppose. But I leave that to the powers that be in administration.
Yeah, I mean, I just for what it's worth, for me, it would be much more meaningful to have the FTR than to have people try to characterize and recreate a record after the fact before the judge. It would be probably useless at that point. Okay, so we've talked about civil. Are there any other discussion items from members of the committee at this time on this proposal?
Your Honor, am I being heard now?
Yes, much better, yes.
Thank you. The technician in this office is a magician. What I would like to just point out is that the mechanism is currently in place. Logistics, as has been explained, would need to be addressed. But the mechanism, when you move to excuse for cause, the judge then has to come out and hear argument. I would point out that that has been the tradition and the proceeding and the norm. And within the last several years, a co-counsel and mine and I, we actually made a Batson objection in a civil case. And in that case, the judge came out and listened to the requisite arguments. I thought they had a complete picture of the circumstances. However, it was the limitations of Batson rather than any logistical problems which led to the denial of the challenge. So that's basically what I wanted to add. It's purely logistics that need to be addressed, and I think in this day and age, they can be pretty easily overcome. Thank you.
Thank you. Well, actually, that brings up the additional benefit of an FTR. If there is a challenge for cause, you would get rid of the mischaracterization of the record as well. You'd have the real-time transcript. So I appreciate that. That was helpful. Is there anything further from members of the committee for any questions to members of the task force? If not, do members of the committee feel that we can move for a motion to approve this rule at this time? And if there is there a motion to approve?
So moved, Judge Bellis.
Is there a second?
Second, Judge Cobb.
It's been moved and seconded. Is there any discussion from members of the committee? Hearing none, all in favor, say aye.
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 Opposed, say no. That passes unanimously. Thank you very much. And I appreciate the attendance of all of the members of the task force, as well as, of course, the current Chief Justice and the former Chief Justice. It's always a pleasure to have you here too. So thank you very much.
Thank
we're
you.
Going to go, we're going to
Thank
go
you.
back. We're going to go back to the agenda. The next item we have then is 2021-011. It's reconsideration of a proposal based on additional comments received or otherwise not considered from Judge Conway's proposal. Attorney Del Campo?
Yes, sir. You, in the minutes of the prior meeting, you approved this proposal that was originally submitted by Judge Conway and adopted by Judge Westbrook. Unfortunately, when you did that, I was not aware that the Chief State's Attorney, Attorney Colangelo, had submitted the comments. I either did not get them or I certainly got them late. So what I put in your package today is what you approved as Appendix B for this proposal, and I put in there also what's new material is Attorney Colangelo, Chief State's Attorney Colangelo's comments on this proposal. So again, you did vote that it go to public hearing, but you did that without knowledge of these comments. So you now have these additional comments.
Thank you. And the letter is dated November 10th, but it appears that it was not received by our staff until after our last meeting on November 15th. So members did not have the benefit of the input of the Chief State's Attorney. Based on that letter, is there any concern about still moving this item forward for public hearing, or would we like to move to, if I remember my Robert's Rules of Order, you can reconsider something at the next regular meeting of the board of the entity. So if there's a desire for us to reconsider this and table it or something, we can certainly do that.
I would, this is Judge Bellis, make the motion, I suppose it is, to reconsider it and give the other stakeholders an opportunity to respond to these concerns.
Is there a second? There's no time lost, really, folks. So there's no impediment to just reconsidering it. We're probably better to deal with any problems on the front end than the back end. So is there a second?
Judge McDaniel, I second Judge Pratt's.
Thank you. That's, as I recall, a non-debatable motion. All in favor, say aye.
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 Aye. Aye.
Opposed, say no. All right, we will reconsider that, and I think we're going to table that and ask Judge Westbrook now and anybody else who had commented on the rule to look at the comments from the Chief State's Attorney, and then if feasible, we will have those comments and their attendance at our, when is our next meeting? Actually, is it January or do we skip a month?
January 10th, Your Honor.
It may not be enough time, but let's put it down for next meeting. And if they need more time, we can put it over until February.
Thank you.
Thank you. The next item is 2021-014, proposal from Judge Noble to revise the standard premises liability interrogatories. Attorney Del Campo.
Yes, this was on your agenda last month. The committee considered this after discussion. It was tabled until today and referred. You referred comments to received from the Connecticut Trial Lawyers Association and the Connecticut Defense Lawyers Association to Judges Noble and Abrams for their consideration. Judge Noble has responded to that referral, and I believe he's here today, and he has modified the proposal based on those comments. But Judge Noble is here if you'd like to address.
Thank you, and just so we're all focused on the same document, I believe this is item 2021-014F. Is that correct, Attorney Del Campo?
Yes, Your Honor.
Okay. Good afternoon, Judge Noble.
Afternoon, everybody. This is a fairly quotidian issue. The practice that I've been seeing is in every premises liability case, plaintiff's counsel has been filing a motion for permission to file a non-standard interrogatory and request for production to get any records or invoices or contracts related to maintenance and inspection of the premises on which the plaintiff fell. I've been granting them as a matter of course. I don't know anybody that doesn't, but this would serve, I think, purposes of efficiency to avoid us having to act on it. And it's information that they generally need in order to bring a third-party claim, among other things, in order to identify who the third-party defendant might be. And the CTLA's modifications, I think, are well taken. I've incorporated them in what I presume is 014F. The CDLA, Connecticut Defense Lawyers Association, had a concern as to the date and location relative to where the plaintiff fell, but I think that was addressed by the CT, the Connecticut Trial Lawyers Association, a modification of my original proposal. It's a pretty dry subject, but I think it's helpful.
Well, thank you, and thank you for your work on it. Are there any questions from members of the committee for Judge Noble? Judge Bellis?
Thank you. This is long overdue. This is a fabulous idea, so I'm in full support of it. I just had two little minor things. For interrogatory 4, do we want to maybe change it a little bit to capture any bills or invoices or records for the day of the incident? You know, sometimes they were there that morning and the incident happened at 11 o'clock and, you know, we don't want to lose out on those. And then the only other concern I had was with number 3. I wasn't exactly sure what the last part of that additional phrase related to a particular season or condition or fixture meant. So I'm wondering if we even needed that language and just, you know, for number 3, just leave what you have. Maintenance and inspection includes, but is not limited to, snow and ice removal. I wasn't sure what we meant by the rest of it, or if maybe we could just phrase it a little bit differently.
Judge Noble?
I think you can get rid of the phrase and other maintenance and inspection includes, so it just reads maintenance and inspection includes, but is not limited to snow and ice removal.
Was there anything else that you were trying to capture with that, or does that pretty much cover it?
That pretty much covers it. I mean, my thinking was pretty much limited to snow and ice. The CTLA's suggestion attempted to capture a great deal more. So if there is, you know, summer maintenance, fall maintenance, that might have implicated a defect, then this would cover that.
So like wet leaves and that type of thing?
Yeah. And with respect to the bills, number 4, yeah, I think that the request for production can include a copy of the policies, procedures, contracts, or invoices or records identified in response to 4 and 5.
I think Judge Bellis was, I think, if I can commandeer the concern, I think she's suggesting that it say the 30 days prior to or on the date on which the plaintiff claims to have been injured, in case it was done that day, the day of the injury.
Oh, I see. Okay. Excellent suggestion.
Okay, so just to be clear, I want to make clear for Attorney Del Campo and his team that in item number 3, we would be putting a period after snow and ice removal and deleting the remainder of that inserted language. And item number 4, it would say maintenance and inspection for the 30 days prior to, comma, or on, comma, the date on which the plaintiff claims to have been injured. Is that right, Judge Bellis?
Exactly. Thank you.
Okay. Well, we'll accept that as a friendly amendment. So as modified by those 2 items, is there a motion to approve this?
Before we do that, may I interrupt? And
oh, sure.
No. Number 1 of the request for production, a copy of the policies, procedures, or contracts. We may want to, I would recommend changing that to read a copy of the policies, procedures, or contracts, procedures, comma, contracts, comma, invoices or records records identified in response to interrogatories 4 and 5. So that the plaintiff would get a copy of invoices and records in addition to the other documents.
Thank you for saving me from myself, Judge Noble. Is there any further comment with those changes? Is there a motion to approve?
So moved, Judge Bellis.
Is there a second?
Second, Judge Cobb.
Is there any discussion? Seeing none, all in favor, say aye.
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 Opposed, say no. That passes unanimously. Thank you for your work on that, Judge Noble.
Everybody have a great day. You're welcome.
We've already done the next item, so then we'll move on to 2021-19, proposal to revise practice book section 35A-1B to remove the written requirement for NOLO pleas. Is Judge Westbrook on?
Yes, I am.
There she is. All right. Attorney Del Campo, did you have any prefatory remarks?
No, I don't believe so. Thank you.
Okay. So I'll turn it over to Judge Westbrook.
Oh, thank you. And I don't know that I realized this was on the agenda for today, but the proposal requests that in juvenile matters for child protection matters, that the requirement that NOLO pleas be in writing, that we eliminate that requirement. I guess we've discovered that during the pandemic, there's been difficulty getting actual written NOLO pleas in when already there's a safety in place, because judges do canvass parents on the record, generally under oath, about their agreement to not contest the allegations that are being made against them. And the written NOLO plea is simply an additional sort of requirement that is redundant and unnecessary. I have consulted with the Office of Chief Public Defender, specifically Susan Hamilton, who is in charge of the contract/panel attorneys. Those are the attorneys who represent respondent parents in juvenile matters, and they would support this proposal. And I'm open to any questions you might have.
Are you aware of any opposition?
I am unaware of any opposition.
That's good to hear. Is there any questions for Judge Westbrook? If not, is there a motion to approve?
So moved, Judge Bellis. I was trying to give someone else a chance.
I think Judge Pratt is seconding. Is that correct?
Well, I actually had a question.
Let's get the second done.
Okay, I'll second then.
Okay, and now Judge Pratt has a question.
All right. Is this just for the juvenile, or has this been an issue also in criminal with like Microsoft Teams and during pleas being done virtually that way? Because it might make sense to do it in the criminal context as well, not just juvenile, if we're doing this.
I guess I would defer to anyone who sits criminal about that. I have not consulted with the CHA of criminal or anyone who sits in the adult criminal court. But it's again, these are not our criminal cases. These are our these are our child welfare cases.
The child, okay, delinquency, not the delinquency.
No, these are not delinquency cases.
All right.
Why don't we, Judge Pratt, if you don't mind, why don't we move with this separately?
Okay.
And I'll ask Attorney Del Campo to check with Judge Gold if he wants to submit something separately for the criminal.
Thank you.
All right.
Okay.
Is there anything further? If not, all in favor, say aye.
Aye.
Aye. Aye.
Opposed, say no. That passes unanimously. Next item is 2021-023, a proposal to amend practice book sections 7-10 and 7-11 regarding retention and destruction of summary process records. That's on this agenda for the first time today. Attorney Del Campo.
This is brand new, Your Honors, and I believe Attorney Shea is here. This was submitted by a group of legal aid organizations headed, I believe, by Attorney Shea, writing to you all. And Attorney Shea, Giovanna Shea, is here, I believe, with some other members of her consortium. So perhaps you would like to address her.
Attorney Shea, would you like to address the committee?
Good afternoon. Thank you for this opportunity to speak with the Rules Committee. I'm Giovanna Shea. I'm with Greater Hartford Legal Aid. I'm here in connection with a proposal by Greater Hartford Legal Aid, Connecticut Legal Services, New Haven Legal Assistance Association, and statewide legal services regarding retention and destruction of summary process records. Would it be helpful for me to briefly summarize the proposal for the committee?
Sure.
Okay, so the goal of this proposal is to reduce the amount of time that summary process filings, especially those resulting in withdrawal, dismissal, non-suit, or a judgment for the defendant tenant, to reduce the amount of time they remain available on the judicial branch website on the internet, and to subscribers who purchase judicial branch data for commercial purposes like screening tenants. So current judicial branch practice regarding case information available on the judicial branch website is governed, as we understand it, by the practice book provisions on retention and destruction of files. That's practice book sections 7-10 and 7-11. And so accordingly, our proposal is to amend those sections. So specifically, we're proposing an amendment to practice book 7-10 that would require the removal from the judicial branch website of case records and all identifying information regarding summary process matters resolved by a withdrawal, dismissal, non-suit, or judgment for a defendant tenant as soon as administratively possible and no later than within 30 days of disposition. Second, an amendment to practice book 7-11 that would shorten the retention period or the period of time that records of summary process actions are on the internet in matters in which judgment entered for the plaintiff landlord from the current 3 years to 1 year. Then we are also proposing a new practice book section requiring commercial purchasers of judicial branch data to update their records to reflect changes to judicial branch data when the bulk data is updated. That's our intent.
Let me ask you, have you coordinated this at all with the chief court administrator? Have you talked to the administration about the feasibility of some of these timelines and whether there's any support or opposition from the chief court administrator?
No, Justice McDonald. So their comment obviously would be very important.
Sure. Yeah, very important. Thank you. Judge Bellis.
I think I agree that would be probably a better starting point because it may not be a rule change. There are a lot of, as most of us know, there are a lot of records that are not on the internet and that's more of an administrative decision. So I'm just wondering, rather than alter records or talk about destroying records, that it's given to the administration before anyone else to look at it to see if there's a way that it's maybe just less accessible on the internet or not accessible like in the old days before we had e-filing and paperless files.
Understood. My understanding from my colleagues is that there's been a sense, and I don't know if this is from the chief court administrator, but there has been a sense from court administration that the timelines set out in the practice book are binding on them for the judicial branch website as well as for paper files. So I think that's why we chose to take it in this direction, because there's a sense that these rules for stripping and destroying paper files, and that's, I think, really what these rules are focused on, that they also govern how long information needs to remain on the judicial branch website by rule. So that's how it came here.
So let me interject here, and then I'll acknowledge a question from or comment from Attorney Podolsky. But I think you're right. At the end of the day, we may need to change some of the language in the practice book. But in my opinion, this would be a much more efficient process if you meet with the administration first to see what they can do administratively versus what they maintain would need to be done by rule change. And I am going to offer Attorney Del Campo's good offices to try to facilitate that type of meeting with the appropriate personnel within the Chief Court Administrator's office. But before we go any further, Attorney Podolsky, who I have not had the pleasure of seeing in probably 10 years, would like to address the committee, and I am happy to acknowledge him at this time. Rafi, you're on mute.
Okay,
There you go.
I'm sorry about that. I was one of the people involved in this, and I, to some extent, I just want to amend something that Attorney Shea said. We, in fact, met with Judicial to discuss this. Maybe I'm not sure if we met with the wrong people, but Melissa Farley was included. I believe Nancy McGann was included. And what we were told was, the reason we brought this to the Rules Committee is we were told that, I think maybe not by requirement, but by custom, the removal of materials from the website was coordinated with the practice books 710 and 711. And what they suggested to us was that we should take the matter to the Rules Committee. And it wasn't really our idea to go to the Rules Committee. They said we should go to the Rules Committee. I don't think there's any problem with referring this to Judge Del Campo or to other people within the Chief Court Administrator or Deputy Chief or any of those. So I'm not objecting to that as a resolution. But I think you should understand that we did meet with Judicial, and they did direct us to the Rules Committee. And the implication, in fact, it was more than an implication. It was that they were not really, that it was a Rules Committee decision rather than an administrative decision. And that my at least understanding was they were not going to change that. They were not going to separate the timelines from the practice book provision.
Okay.
The practice provision should be adjusted. So I'm sure we're happy to meet with anybody, but I just want you to understand we did in fact go to Judicial first. This
I appreciate that clarification. Attorney Shea, is that your understanding as well?
Yes.
All right, so that changes my view at least. I would recommend that we accept this proposal and that we ask for comments from the Chief Court Administrator's office about the proposed rule change. Does that sound like a good plan of action to other members of the committee? I'm going to take silence as acquiescence. In addition to the Chief Court Administrator, is there maybe we should also give it to Judge Abrams, just to Judge Bellis?
Yeah, I think it would make the most sense to get it to the Chief Court Administrator first and to the e-filing committee who deals with the accessibility on the internet issues before we start giving it out to different stakeholders, because I think there's a lot that actually can be done if you get to the right person with respect to what is shown on the internet versus what is not shown on the internet. So before we give it out to all the other stakeholders, I think it really makes more sense to get it to the branch and to the e-filing committee and let them do their job. Because, for example, when the e-filing committee made the decision not to have e-filed paperless family records accessible on the internet, that was not a rule. That was an administrative decision that we made through the e-filing committee. And there's a lot of other things that are similar. So I think that that's probably a really good first step.
I think that's a good cautionary note. Is there any objection to at least initially just sharing this with the Chief Court Administrator and the e-filing committee for their initial comments? I will take that as acquiescence and thank Judge Bellis for that recommendation. So we will.
Excuse me, Your Honor. I'm sorry, Judge Bellis. When you said the e-filing committee, you're meaning the Judges Advisory Committee?
The Judges Advisory Committee that Judge Carroll chairs and PJ Deek, I think, co-chairs.
Okay, thank you.
So First of all, thank you for bringing this proposal to us. We will try to keep this on a relatively tight time frame if possible, or we will put this on our agenda again for next month and hope that we will have the input from the Chief Court Administrator and the e-filing committee by that time. Okay?
Thank you.
Thank you.
Thank you.
Next is item 2021-024, proposal to amend sections 2-8 and 2-55A to add a reference. This is a proposal, I believe, from our council. Is that correct, Attorney Del Campo?
Yes, Your Honor. Attorney Petrozelli can take us through that.
Attorney Petrozelli, are you there?
Hi, Your Honor.
Hi.
Yes, these two proposals are more like the same style of housekeeping as I presented at the last meeting. The Reporter's Office of Judicial Decisions, as you know, does a very careful review of the practice book and makes some technical changes. These actually are making a change to a rule reference number, so we felt it was appropriate to bring it in front of the Rules Committee. Basically, for rule section 2-8, it's to include a section for Rule 2-13A, which is the temporary licensing of military spouses. And that reference is just simply to flag that if one seeks to be temporarily licensed under that provision, they should not refer to section 2-8, but should be directed to section 2-13A. So.
Thank you. By the way, I should have noted for the record that Judge Trulia joined us approximately 10 minutes ago. With that having been said, this strikes me as a highly technical matter that doesn't require any additional work or input. Is that, people are agreeing and shaking heads?
Sure.
All right, so is there a motion to approve that?
So moved, Judge Prats.
Thank you. Judge Billis, do you second that?
I do.
Is there any discussion? Seeing none, all in favor, say aye.
Aye.
Aye. Aye.
Opposed, say no. That passes unanimously. Thank you very much, Attorney Petrozelli.
Your Honor, there's I guess we were handling them separately. There's a second
Yes.
motion that would be needed, I believe, with your permission, of course, for section 2-55A. It's also of the same nature, which is including a reference in subsection C to the military spouse rule 2-13A. And again,
I took our vote to be for both.
Oh,
Is
okay.
Is that everybody's understanding?
Yes.
Yes. Okay.
That's fine.
Okay, thank you very much.
Thank you. Next is item 2021-025, a proposal to amend practice book section 2-44A and rule 5.5 of the rules of professional conduct. Attorney Dale Campo, and I believe Attorney Stoll is with us as well.
I can't see right now, Your Honor. I believe she was invited. This is brand new from the Connecticut Bar Association. Obviously, it's a substantial proposal. If Attorney Stovall is here, I'm certain you would like to hear from her.
She actually doesn't. Oh, there she is.
She is.
Attorney Stovall.
Thank you. This is, I think, actually a very simple proposal. I think everyone is aware that with the pandemic and also changes in technology, there are more and more lawyers working remotely. And the proposed rule change is a change to both practice book section 244A and rule 5.5 of the rules of professional conduct. And it's to address the situation where a lawyer who is licensed in another jurisdiction, but for example, lives in Connecticut and works remotely from a home office in Connecticut that is, as these usually are, electronically tied in to a practice in another state in a jurisdiction where the lawyer is licensed, that in that situation, that practice where the lawyer is not holding herself out as licensed to practice in Connecticut, is not offering services to Connecticut consumers, but is working with clients in the jurisdiction in which the lawyer is admitted or engaged in practice, it would be permitted if she were physically present in her home jurisdiction, that in those circumstances, the practice would not be considered the unauthorized practice of law. There's a gap in our rule that it would be hard for a lawyer from another state to look at our Rule 5.5 and know whether or not that practice would amount to unauthorized practice of law in Connecticut. So this is intended to address a quite narrow, quite modern problem that the rule in its existing form just doesn't address.
So for the so this is to address the needs of people from New York law firms with houses in Old Saybrook who want to ride up the pandemic from there. Basically.
Exactly. Or I mean, it would even apply to someone who wasn't doing it on a long-term basis and working on during vacation, which I'm sure there are plenty of lawyers who do that. It would also provide the benefit for Connecticut lawyers is that it would be if a Connecticut lawyer was engaged in the same conduct somewhere else, say living in New York and practicing remotely from New York, that would not be considered unauthorized practice by Connecticut's disciplinary authorities under the proposal. That's
could you say that again? I'm sorry, say that last part again.
It would also work so that in Connecticut, a Connecticut lawyer, Connecticut licensed lawyer working in New York remotely would not be considered unauthorized practice of law by Connecticut's disciplinary authorities. Obviously, we can't control what New York does, but Connecticut's disciplinary authorities, it wouldn't be a violation of Connecticut's UPL laws or rules for a lawyer to do that. Did I explain that clearly?
Yes, I understood it the second time. Let me just ask you, out of maybe just curiosity, what has happened during the pandemic with attorneys who are admitted pro hoc vice, who are videoing into hearings in Connecticut from Chicago or LA? Are there any rules problems with the reverse happening, where they're not here physically and don't have their sponsoring attorney with them?
Well, I can't speak to that specifically, but I would imagine, but because I don't know of any particular issues with that, but if a lawyer is admitted pro hoc vice in a Connecticut proceeding, then that practice is authorized. There's not a question of whether that amounts to unauthorized practice. And to the extent that the rules require that a Connecticut lawyer be present, then I suppose that's up to the judge hearing the matter to set those rules. I know that there have been instances where a judge will, in a particular matter, will waive that requirement that the Connecticut attorney be physically present, but I don't know that that's occurring on a regular or occurring more frequently because of the pandemic.
Thank you. Are there any questions for Attorney Stovall for members of the committee? I have to confess, I have not had a sufficient amount of time to look this over. I breezed through it rather rapidly. I would like a little bit more time to look at this. I don't know if that's true for other members of the committee as well. Okay. In the meantime, can Attorney Stovall or Attorney Del Campo identify whether we need input from any other stakeholders? Attorney Stovall.
Well, generally, you ask the Office of Disciplinary Counsel and Bar Counsel to weigh in on changes to the rules of professional conduct.
Right. And I see Attorney Staines is on here as well. So other than those two, Attorney Del Campo, any suggestions, or is that sufficient?
No, I believe that's sufficient, Your Honor.
Okay, so why don't we refer it out to those two, and then that'll give members of the committee a little bit more time to look at this proposal. Thank you very much, Attorney Stovall.
Thank you. Thank you, Your Honor.
Next is item 2021-026. It's a proposal by the Chief Court Administrator to amend practice book sections 1-11A, B, and C. Attorney Del Campo.
I don't have a lot of information for Your Honors on this. It is brand new, submitted by the Chief Court Administrator on behalf of the Judicial Media Committee. The changes are straightforward. I believe they are to update these rules based on current practice. I believe they went through the different, through external affairs and the media committee before they went to Judge Carroll, and he is presenting them on his behalf, on its behalf.
Thank you. I don't see either Judge Alexander or Attorney Parker on here. I think Attorney Farley is on.
Yes, she is.
Melissa, would you like to address this item?
Sure. Thank you very much, Your Honor. As you may know, the camera rules took effect over 10 years ago, and the purpose of these rules is to streamline the camera rules. As you may know, the vast majority of requests we get from the media is to cover arraignments. And there's different processes in place for the media to cover arraignments versus other criminal proceedings and other civil proceedings. So, for example, if a member of the media wants to cover an arraignment, the rules require that that media organization send an email to the External Affairs Division, as the Chief Court Administrator has designated the External Affairs Division to take these requests. Then we get them into the field and get decisions from the judges and let the media know. The difference for other criminal proceedings and civil proceedings is the rules require that the media submit a request at least 3 days in advance of the proceeding to the administrative judge. So what has happened is that at times the media is confused who should get the email. And the other thing is that administrative judges get a whole bunch of requests, and some of them have fallen through the cracks. The other issue is the pooling requirements. The media does a great job in terms of pooling, and the 3 sections of the practice book are all different with regard to the pooling requirements. So all that this rule does is it requires the media to submit a request to the person designated by the Office of the Chief Court Administrator, which we think would be the External Affairs Division. And then the process is the same up front for the media. And we went through the rules and we have standardized the language regarding pooling requirements. I can go through each section if you want, but that's basically what the rule does. The Judicial Media Committee reviewed it in September, unanimously approved it. The Chief Administrative Judge for Civil, Judge Abrams, and the Chief Administrative Judge for Criminal, Judge Gold, have all approved the changes.
And just remind me again, who's on the media committee?
It consists of judges, and it consists of media representatives, and it also consists of some lawyers that practice in the media arena, like Bill Fish.
Got it. Okay, I appreciate that. Are there any questions for Melissa Farley, members of the committee? All right, I have to tell you, I really appreciate a prepackaged proposal like this. Judge Kratz.
Thank you. Melissa, the to whom is very clear to me, but still the media pooling is a little bit of a, concern for me. So when we get the request, we usually get something from like an email, right? And we approve usually. So this is, they decide amongst themselves who is the one who's going to be coming into court. And if they can't decide, then the issue is presented to the court and then the court makes a decision?
No, that's exactly what we don't want to happen. And,
okay.
And we have not had that problem in the past. So the way it works is usually the first media representative, either pool or still, is designated as the pool. And then there are times when whoever the pool photographer is or the pool videographer is can't do it. They work it out amongst themselves. So we don't want to be involved in that, and we don't want the judges to be involved.
Because I've never been. That's what I was going to say. Like, I just approve, and then someone always comes in court. So I wasn't sure I understood the media pooling part of it. Okay, thank you.
You're welcome.
Melissa, what would happen if the first in line doesn't want to facilitate the pooling?
They know that if they put in a request, that they are automatically required to do the pooling. That's part of the agreement that's signed up front when somebody is put on the list of approved media, that they have to agree to be the pool.
Okay. What would happen if a video blogger was the one who wanted to tape it, but had an interest in not sharing it?
So
how is it enforced?
Right. So One of the rules that we're not suggesting be changed is section 1-10A, and that is the definition of media. And it basically says, for purposes of these rules, media means any person or entity that is regularly engaged in the gathering and dissemination of news and that is approved by the Office of the Chief Court Administrator. And I can tell you that the Judicial Media Committee has spent a lot of time in terms of defining what media means. And what we've come up with is a form. And there probably are some bloggers that meet the requirements, but if they want to be on this approved list, they have to agree to serve as a pool. They sign an agreement to do that. And if they don't want to serve as a pool, they cannot be included in the definition of media.
Okay, I appreciate it. Are there any other questions for Melissa or Rhonda? It's good to see you, Rhonda. All right, I don't see any impediment at the moment to moving straight to a vote. Does anybody object to that? If not, is there a motion to approve?
So move, Judge Bellis.
Is there a second?
Second, Judge Juliet.
Thank you. Is there any discussion? All in favor, say aye.
Aye.
Opposed, say no. That passes unanimously. Good to see you both.
Thank you.
All right. Is there any other business that needs to come before the committee, Attorney Del Campo?
No, Your Honor.
If not, I will accept well, before I do that, I wish everybody a happy holiday season. And I will see you in the new year. But in the meantime, is there a motion to adjourn?
So move, Judge Bellis.
Is there a second?
Second, Judge Cobb.
All in favor, say aye.
Aye.
Opposed, say no. We'll stand adjourned. Thanks very much, everyone.
Aye.
Aye.